evening. Today is May 21st, 2025, and we are the District 3 Environmental Commission meeting in Strafford, Vermont, to conduct a hearing conference on application 3R1135, filed by Rachel Kendall, for the use of existing buildings for women's wellness, including regular yoga classes, weddings, receptions, and a musical event on a tract exceeding 1 acre. Weddings, receptions, and a musical event on a tract exceeding 1 acre located at 20 Kendall Road in Strafford, Vermont. My name is Ashley Lincoln. I'm the acting chair for this hearing. I reside in Randolph Center, Vermont. My fellow commission member here is Suzanne Butterfield of Stockbridge.
You're good.
This is our second day of hearings following the recess of this matter on April 9th. As such, we will skip most of the preliminary and jump into the remaining criteria that we did not discuss last time around. But first, I want to provide some brief reminders about how we will conduct this hearing. The recordings from our first day of hearings are available on the Land Use Review Board's YouTube page. We do not plan to cover ground we have already discussed. This meeting is subject to Vermont's open meeting laws. By participating, you are consenting to being audio and visually recorded, and for that recording to be published in the board's online database and YouTube channel. In addition, any written information or exhibits provided to the Commission or Act 250 staff regarding official state business are considered public record and will become part of the permanent record to be published in the board's online database. The chat function has been disabled for this team's meeting. The hearing is being recorded, including any noises, like personal conversation, made when your microphone is not muted. Therefore, please mute your microphone when not speaking. If you would like to speak during the hearing, please raise your hand if you are in the hearing room. If you're participating online via Teams, please use the raise hand feature, which is located in the toolbar in the top center of your screen. If you're participating exclusively by telephone, press *6, unmute, and speak up so we can hear you. For the audio-visual record and for the benefit of those participating solely by telephone, please state your name before speaking and, if relevant, your street address. Finally, and this is important, please do not log into the Microsoft Teams meeting on a computer or other device and participate on your phone at the same time. This will cause some very distracting audio feedback and can disrupt the hearing. I have to do the attendance. Very good. Okay. Coordinator Pete Costco could get that. So outside of today's proceedings, may I remind everyone that all communications, whether by letter, email, telephone, or in person, must flow through Pete Costco, our district coordinator, and not through other parties or commission members. We're now going to administer the oath. I'm going to ask anyone who thinks they might address the commission during this hearing to swear or affirm that they will tell the truth. Accordingly, anyone who expects to address us, please raise your right hand. Do you solemnly swear or affirm that the testimony or evidence that you shall provide relative to the consideration of this application shall be truthful, accurate, and complete under the pains and penalties of perjury? If so, answer I do. Okay. Does anyone have any questions at this point about the process that we will follow? Okay. Last time we covered the following criteria. Criterion 5, criterion 8. Today we will address the remaining criteria. We ask that parties be mindful of our time. We should be able to close the hearing today, preferably by noon. So accordingly, please focus on testimony and evidence. We can address legal arguments in the recess period. So the criterion that we're going to cover, criteria 1B, waste disposal as it relates to wastewater. Criteria 1B and 4 relating to stormwater. Criterion 1E, streams. Criterion 1G, wetlands. Criteria 2 and 3 relating to water supply. Criteria 8A relating to relating to wildlife habitat. And criteria 10, town and regional plans. We will also address any facts and arguments the parties have about reducing the jurisdictional area under 10 VSA section 6001, section 3E. Okay. I'm just going to turn it over to the applicant, who should present a general overview of the project in brief and address the criteria.
Could I just do some housekeeping to make sure we've all got all the same information? We have, I think there were some follow-up items from the last hearing. First of all, A&R raised some questions. We responded to those, and we haven't heard any more from A&R indicating that we need to do more to respond to those. We have revised the lighting plan, and the reason for that was to make it clear as to some lighting that was within the area that we didn't want to be jurisdictional, Act 250 jurisdictional, so we removed that lighting from that area. And I assume the site plan is also adjusted.
That was more for the lights.
Okay. I also sent in a decision on vested rights that was rendered by the environmental court in this case, indicating that the ordinance, the town zoning ordinance that's applicable to this project is the 2007 zoning ordinance, not the 2000 and whatever it was, 23 zoning ordinance. I also sent in a letter to the town concerning accessory on farm use in order to, I thought that we very thoroughly outlined why we think it qualifies as accessory on farm use. And so I submitted that. That came up proliferately. I'm happy to address that, but the main thing there is that we have a decision from the state saying it qualifies as accessory on farm use. I also submitted there were questions that came up about designing shields, noise shields, and I submitted a brief letter from the acoustic, the sound person, outlining the considerations of designing a shield for a bathroom. So I think with that, I think all of the criteria that are up for consideration until we get to 10 are yours.
Well, actually, yeah, the A&R response that I sent in addresses basically all of the outstanding criteria other than intent. For instance, the wastewater, stormwater, both were both addressed, and then the biggest one was the wetlands, the 1G. I had a conversation with Elijah, who was on the A&R, recommended the A&R discussion, and I modified the site plan a little bit based on what he said, because what we had before was the 50-foot offset from straight lines on the wetlands slides that were out there, and the corners of the wetlands produced a fairly sharp angle, which when offset 50 feet and merged together, made those points more like 75 feet away from the wetland. And being that the wetland requirement is a 50-foot buffer around the wetlands, we agreed that we should do a circular offset around those sharp angles. And that made the wetlands not impacted, the wetland buffer not impacted at all. So there was no change in the proposed parking area, just the buffer of the ground. Rest of the stuff was pretty well straightforward in the A&R discussion.
Why don't you just briefly summarize the under what's relevant under 1B in that respect?
1B is a water wastewater permit.
We have the permit, we're relying on that to show compliance.
Yeah, there really wasn't any change to the permit or anything like that. I think it was questioned about essentially what the use would be, and that was written in the permit, about the event use, that they would need to be only the preference of exemption in the state wastewater rules that says if you can have 12 events outside of the permit per year, 12 event days outside of the permit per year, provided we put in some more back and forth. So that's kind of what we've been working on for this application.
Under stormwater, we fall below the jurisdictional limit for an operating permit. So there's no requirement to file, get a state stormwater permit. How did you design the stormwater treatment?
Yeah, we just did standard things like on some swears and some, where it required some stone checking and schema, but like John said, there's no, we don't trigger the stormwater criteria for permit. We do not compete. And on the water side, there's also labeled out in the permit what the limitations are, what the requirements are. If you get to a certain amount, we're going to need to get a public water permit. We're not going to go to that extent in order to get it. The project is not planned to be near that the number to trigger that public water. The wildlife was about the bats and trees. That was, there's no plans to cut any trees. That was essentially bottom line on the American food. I think the streams are, I'm trying to remember now, but the are happening like that. I think that would be due to the pushing. Other than that,
So that's a question with streams, any habitat issues there? Any stream buffer area requirements or?
no, we're actually not near any no significant streams. There's one over the edge of the property, but they're not.
We're here to entertain you, but if you have questions, we'll try to respond.
Just on that point, if I may, if A&R were to request, stream or wetland buffer conditions in the permit, particularly on the side of the road where the parking area is, what's your position on that?
You can meet the buffer conditions based on the conversation with Elijah and the answer to the question he had about the buffer. Is it before what I had shown you was the pointed buffers?
Yeah.
Like 65, 75 feet away, and you need that.
No, I guess what I'm thinking is sometimes A&R, and it's unfortunately not here to confirm whether or not they're going to request this or not. You know, they'll ask for a condition in a permit that says, you know, no mowing, you know, no disturbance, no placing snow in the wetland buffer. And sometimes they request like fencing or signs or stones. I don't know if they can request that here, but if they did, I'm curious what your position is with that. I mean, this touches on the reduced jurisdictional area issue. If there's a condition, I think that the lands that are subject to that condition.
So I have two responses. And the first is that the wetlands rules allow us to keep farming in areas that we've been farming, there's a specific, and we've been mowing that for hay. So I would be surprised if A&R says we can't keep cutting hay. And that's the only disturbance is what we have been doing. I believe though that given to get this thing done, my clients would probably consent to a condition that we couldn't disturb the if it were put forward. I can't, I hate to speak in hypothetical.
No, we can address it in the recess period too.
Did speak to Elijah about that, because in the question, there was mention of plowing and that kind of thing. None of that is going to happen here. This field, we use, no more than 12 times a year. And so they weren't going to, when I talked to him, they weren't going to require all of those things to be in the plowing. That's my belief would be that they wouldn't require some sort of delineation because it is the value. And actually, we got a minimus, it's from our agriculture related to back to the region, a little bit of agriculture and not permanently. We have that money.
My question would be around farming. So it's hay. When you talk about farming and agricultural use, you're focusing on hay this year.
Right.
And
Yes. I've got a case that I've had to go, I've got a case right now that I've had to go into this very deeply. And I've had a number of conversations with the ag agency, and as long as we're using it, we believe that as long as we're using it for ag purposes, we can use it for all ag purposes, we can continue to use it for that.
And that's just the parking area. Is that what you're referring to?
Yeah.
Just the parking.
So,
Okay.
so really I understand that, correct me if I'm wrong, the only change is that we park cars there once in a while. Probably we would cut the hay for the weekend we were parking cars, or the day we were parking cars. But that's the only change.
Do you do anything with the hay or just cut it and leave it alone?
Yeah, horses. We have a horse credit on that. And we play in that corner.
So you use for food?
Yes.
And I'm pretty sure I heard you say that you were maintaining the current, we'll call it the trees to help with both sound barrier and light barrier.
But we're not proposing to add anything, because if we add plants, then it begins to look more like an urban or suburban, and we're trying to maintain the rural.
Also, that we have maple trees along the road that we are part of our farming as well. So those are right along the road.
But to get this done, if you want something,
No, I'm just curious.
we're not-
Thank you.
we're easy to do business.
That costs on your farm.
Yeah. I just wanted to add that I have 8 fields. They have to be on. And it's just a very small one, 3 weeks ago. The other people are much larger. And the top will not run down. Because there's a responsibility.
Okay. So do you have any other statements before we turn it over?
Other than just being respectful of the area and you mentioned flagging the area, one of my dear friends and father's best friends, Uncle Brown, did Charlie Brown party years. And we will, make sure that things are flagged for the area and not, people license will. But so that we're respectful of our viewers. We do that. Okay, great.
And could I just ask, before you turn it over, do you want us to comment on criteria 10, or is this just on all the other?
Let's let them.
Yeah.
I suggest, because I think we're gonna have some.
Yeah, so we'll hold on criteria 10 and then move over here.
Thanks.
Great, thank you.
So I'll start sort of on the housekeeping front before I talk about the substance. The new materials that were referenced were received either Friday afternoon, the 16th, or yesterday afternoon at 3:06 p.m. This is now the second time we have received materials late in the afternoon, the day before the hearing. I only had a chance to look briefly at the materials we received yesterday, but there is a new report or letter, whatever you want to call it, from the sound consultant. It is unclear to me and will need to be looked at by my client's team, what's in that report, and if it is proposing changes to what we talked about with respect to sound at the first hearing. I thought we were done with 8. I have no interest in going back there, but if the applicants are proposing something different than what we talked about the first time, it may be that we need additional testimony on criteria 8. What I would suggest is a minimum of 35 days after this hearing for written submissions. And the way I've arrived at 35 days is it was 39 days from the date of the last hearing until yesterday afternoon, when I received this material and my clients received this material. So all we're asking for is the same amount of time that the applicants had to review this material and respond as necessary. I think I'm hopeful large parts of it can be addressed with written submissions, but if they propose to change the site plan in some way with respect to noise beyond what they've shown in what we received on Friday, then we may need to speak with their sound consultant again.
May I respond to that? I would note that, just on the afternoon before our last hearing, we received from, Mr. Boyle, I think it was about a 70-page submission on the day before the hearing. I did not intend, that contained a great deal of substantive information to which we responded. We hustled to respond. I did not intend any of this to be terribly substantive. It's merely housekeeping details to get everything up to speed as you requested it. There's no substantive change in the letter from the sound consultant. He simply says, this is how I would define baffles, and here's some manufacturers for the baffles. And we would object to delaying comments by 35 days, as we're trying to line any appeals that may occur in this case up with a trial that we're going to have on the zoning application. And 35 days, I think, as Mr. Boyle probably knows, will substantially interfere with the proposed schedule that I've put in front of the board. So I'm hopeful that we can wrap this up in time to get any appeals surfaced and get them before the court so we can go forward with the 2 cases. Thank you.
Yeah, just briefly, I would point out what I submitted the day before the hearing was a request for party status, which I'm not even obligated to do in advance. I could have shown up at the hearing and said all that out loud. So technically I was ahead of schedule. I am not the applicant here. I can only respond to changes in the project. I assume since they submitted these materials to you yesterday, they're something they rely on in support of their project. All we are asking for is the same amount of time they had in between the last hearing and when they produced those materials to us to review and respond to those materials. I want us to do this once and get it right. I don't want us to run into a Rule 18F problem or a 10 DSA 6085F problem where the hearing is closed without there being, quote, an opportunity for all parties to respond to the last permit or evidence submitted, close quote. So I'll stand by my request to do 35 days just to make this fair and prevent us from having to come back here. On the substantive front, we'll get into farming when we talk about involved land. I would just note that there has been no determination that they qualify as an accessory on farm use. That is flatly wrong. There is a letter from the Agency of Ag that gave them a farm determination, but as we'll talk about later, that letter was based on an incomplete set of information and is contradicted by the applicant's own statement. So we can table that for now, but no one has said they qualify as an accessory on farm use. With respect to vested rights, again, I haven't had a chance to look at the materials that the applicant submitted. The court's determination regarding vested rights pertains specifically to the applicant's first conditional use zoning application. It did not address in any way which rights apply in this Act 250 proceeding. That's something we can address in legal argument in the recess memo. With respect to the substantive criteria, my client's comments with respect to criterion 1 were all related to noise pollution. I would echo, no pun intended, what I said at the first hearing with respect to noise and sound under criterion 1 and noise pollution. I hope we don't have to go back there for further discussion. We'll see what happens with the applicant's sound report. With respect to criteria 2 and 3, we would echo A&R's comments. We believe that if there is any permit issue, which there should not be for other reasons, that a condition should be included memorializing the representation the applicants made to A&R in their correspondence regarding their wastewater and water supply permits. Specifically, the buildings on the land at 20 Kendall Road shall not be used by more than 24 individuals for more than 60 days per year. Additionally, no more than 12 days of events shall occur per year, and no event shall last more than 4 consecutive days. Again, it shouldn't be an issue because the permit application should be denied, but if you were to conclude otherwise, we would ask that that permit condition be included.
We have no objection to your holding us to what we said we would do.
I would also note, and this falls to A&R more so than me, there have been statements that there will be no additional construction or there will be no additional tree clearing. And that statement might be true, but I think it's incomplete because the tree clearing and the earth moving has already occurred since the construction for this project has been going on for years now. So just something to flag with respect to the issues A&R raised. I did want to point out briefly with respect to criterion 7, there was ultimately the municipal impact questionnaire submitted. There was an indication that there would be an impact with respect to road maintenance. So I would just encourage all of you to look at that when you are evaluating criterion 7. Obviously, that can't be the basis for denial, but something that needs to be addressed with condition. With respect to criterion 1, 2, 3, 7, that is the substance of my client's comments. We're finished with respect to 5 traffic, I believe.
Sorry, okay.
Okay. We'll talk about 10 today, and if we have to do more on 8 and down, hopefully we won't, but we'll deal with it when we come to it, I hope. Thank you.
If I might respond
I'm
very.
sorry, can I just get that? Okay. I just want to. Thank you, sorry.
The tree clearing was done for a building, to construct a building that was permitted by the town and was not jurisdictional under Act 250. So, there was some tree clearing that was done, but, it was all on the up and up. With regards to vested rights issue, Mr. Boyle referred to cases, and I'm sure he's gonna do it again, as to which zoning, bylaw applies. The case that I submitted, both of us have had for 3 or 4 months. I didn't enter any commentary on it. It should come as no surprise, but it does address the issue of which zoning bylaw applies to Rachel's project. And it is the old bylaw which has the less rigorous sound requirements than the new.
I have just brief comments on construction and when jurisdiction was triggered. First of all, there has been no certificate of compliance issued for the building that is currently under construction. Second of all, the permitting of that building as a barn and subsequent modification to barn studio was an act of subterfuge. What the applicant did was go into the zoning office and ask for a permit for a barn, which of course she was going to get. You want to build a barn, you're going to get a permit to build a barn. She then went out, and the initial permit was issued on June 18, 2021. The applicant then went out and purchased to the tune of $307,247 from Coventry Log Home the Lancaster Complete Package, which is a 4-bedroom, I believe 2.5 bathroom log home kit. She included a 12-foot by 24-foot open porch addition and finished flooring on the first floor and loft. So she went and got a permit for a barn, went and bought the kit for what is under construction today, which has been described to you as an inn. So while I agree she got a permit for a barn, there was never any intention to build a barn. After she purchased what is now acknowledged in this proceeding as an inn, the applicant went back to the town, presumably recognizing that no one with any common sense would view what she was doing as a barn and requested the permit be modified to a barn studio. Now, it was never a barn. It's not a barn studio. There is no certificate of compliance that has been issued. So as it exists today, it is unpermitted and illegal construction. With respect to jurisdiction, when the shovel went in the ground, jurisdiction was triggered over the entire tract of land because it was the construction of an improvement for a commercial purpose, which has been acknowledged to you as an inn. So when all the tree clearing, when all the earth moving occurred, that was jurisdictional because what is being built and what has always been being built there is something other than a barn. I am happy to share with you the literal receipt and the permit investigation.
Can I comment? Oh, I would like to correct him, because he's incorrect.
Rachel, what's, frankly, I'm not sure why we're going into this. If no enforcement action has been brought, as far as we know, we are in compliance with the zoning ordinance, we're in compliance with Act 250. And I hope that this kind of mudslinging doesn't substitute for an analysis of our permit, of our compliance with the underlying criteria. If anyone wants to bring an enforcement action, we're happy to respond to it. We don't think there's an enforcement violation, and I really think this mudslinging is not appropriate.
Just so we are clear, I was responding only to the suggestion that the tree clearing was done in connection with permitted construction of the barn. Not mudslinging, simply articulating my client's position that there was never construction of a barn, the permitting of which is not, it is, in my client's position, unpermitted and illegal.
And I was responding to the allegation that there had been tree clearing as to, I didn't raise that issue. I wanted to make clear that it was legally done. And if anyone wants to contest that, then this is not the appropriate forum to do it.
Okay. So we're going to move to criterion 10. Criterion 10.
Okay, so I, on April 7th, 2025, I submitted a letter, analyzing, further supporting beyond the application, our compliance with the municipal plan. Basically, it's my understanding that, the portions of any municipal plan that we have to, it's important to read the municipal plan to try to give the town a project that sort of is in line with what the town is looking for. But in terms of applying the Act 250 criteria, the case law has developed that only clearly written standards are enforceable. So there may be a lot of, any plans are like the Bible, there's a lot of language that people may try to attack, may try to get meaning from, but you look at what is the mandatory provision plan, and that's what you try to follow. So my letter on April 7th extracts what I think are the mandatory provisions in the municipal plan and shows that we're compliant with it. I'm happy to go into detail for that, but the letter, I think, the letter was intended to speak for itself. Do you want me to go into detail? I'm happy to. There are, let's see, four policies that I think have mandatory provisions for them.
I mean, I think we're going to hear from Chris, and I think we're going to hear from Chris. So we may as well. We do want to wrap up pretty quickly, but it looks like we're on track.
Okay.
So as much ground as we can cover.
Okay. So, policy 1 says that development should be at a low density. This is 2 buildings on 14 acres of land. That's low density. It says no primary retail development. Policy 3 is no primary retail development shall be located in the rural residential 1 district except small-scale businesses with a secondary retail component may be allowed. Rachel does not have any primary retail, although she may sell some, there's a secondary business, she may sell some agricultural products. Policy 4 says that there should be no development permitted except the following. And among those are inns, development directly related to agricultural, forestry, and agricultural uses. Rachel has proposed all of her uses fall either as an inn or as recreational use. And they also, we believe, some of them are accessory on farm. And then finally, policy 5 is all commercial and retail development must be convenient with the purposes of the district. Rachel's project is consistent with the purposes of the district, which is to provide for low density residential development while allowing for continued agricultural and forestry operations and some limited commercial uses that are in keeping with the pastoral landscape and provide services of sources of employment. We think we can find that. And I'm not aware of anything in the regional plan that has a mandatory provision.
So there's some agreement here. We agree the properties are located in the rural residential 1 district. And we agree there is mandatory language in the town plan, which says no commercial development shall be permitted except for the following. Then there is a finite list. That finite list is small professional offices, inns, development directly related to agricultural, forestry, and recreational uses, and home occupations such as wholesale operations, internet marketing, carpentry, woodworking, and vehicle and small engine repair garages. If this project does not fit within that finite list, it is not the type of commercial development permitted by the town plan, and it does not comply with the town plan. This proposed development, which is an event venue and wedding space, does not fall within that finite list and therefore is inconsistent with the town plan. If you look at the application itself, it does not at any point refer to an inn or an outdoor recreational facility. Those descriptions of the project were first raised in the letter that Attorney Anderson referenced from April 7th of this year, which again came shortly before the last hearing. And you have to ask yourself, well, why would those descriptions come up for the first time shortly before the hearing? I would suggest that they came up because the applicants recognize what they actually want, an event space and wedding venue, is prohibited by the town plan. The applicants know that, 1, because the town plan is clear, and 2, because the town DRB previously denied zoning application on the basis that the project did not comply with the town plan. When the applicants say to you that this project is an inn or an outdoor recreation facility, they are misrepresenting the nature of their project. They are doing that in an attempt to entice you to permit an event space and wedding venue, which is clearly prohibited by the town plan. You do not need to take my word for it that this project is an event space and wedding venue, and that any other description is a misrepresentation, because the applicant, Rachel Kendall, has already sworn the state of Vermont under pains and penalties of perjury that this project is an event space and wedding venue. In October of 2023, Ms. Kendall applied to the Community Recovery and Revitalization Grant Program, which was administered by the state of Vermont's Department of Economic Development. The application included an attestation And I'm going to read this because I think it gives you a sense of the standard of truthfulness to which these representations are held. As the applicant of CRRP funds, I attest, under penalty of perjury, that all information provided in this application is true and accurate. I understand that the state of Vermont will rely on this certification as a material representation in making this award. Further, I understand that intentional misrepresentation of information is fraud and may subject me or my organization to disqualification from receiving further benefits, administrative penalties, and criminal prosecution. Any person who knowingly presents a false claim for payment to the state is at risk of criminal prosecution, including up to 5 years imprisonment and a fine of up to $10,000, and may also be liable under the Vermont False Claims Act for up to 3 times the amount falsely claimed, plus a penalty of $5,500 to $11,000. Subject to all of that, Ms. Kendall described her project as follows, quote, Old City Falls Oasis, doing business as Vermont Maple Wedding, is a Vermont-based company in Strafford, Vermont that will offer event venues and retreat space, period. The events we target are multi-day weddings and gatherings. The address for the project is identified as 20 Kendall Road, same address as this project. The total projected project cost is $1.45 million, and the amount requested in terms of the award was $290,000. That application resulted in a grant being awarded to Ms. Kendall by the state of Vermont Department of Economic Development. And that award is memorialized in a grant agreement. The total amount awarded was $232,000. Now, the grant agreement, which Ms. Kendall signed, has that same language about perjury, imprisonment, fraud, it's not true, that I just read to you. It includes an additional language that says grantee must repay the award or portion of the award to the Agency of Commerce and Community Development if any funds received were issued in error or are based on incorrect representations. So again, some really nasty language about what happens if the stuff in here isn't true. The grant agreement on page 2 describes the subject matter as follows, quote, the subject matter of this grant agreement is the capital investment and renovation of the event space and wedding venue located at 20 Kendall Road, Strafford, Vermont, period. With respect to project overview on page 5, the agreement says, quote, grantee is a Vermont-based company in Strafford, Vermont that will offer event venues and retreat space, period. The events targeted are multi-day weddings and gatherings. So that is multiple locations in which the applicant said to the state of Vermont, the project at 20 Kendall Road is an event space and wedding venue. The applicant's own email correspondence confirms that that project, as described in the application and as memorialized in the grant agreement, went forward. On July 16, 2024, Rachel Kendall writes to one Ellie Beckett at the Agency of Commerce and Community Development. Good morning, Ellie and CRRP grant team. We are pleased and grateful to report our expansion project is underway and progressing forward as planned. The applicant has received roughly $77,000 so far, I believe, from that grant, and stands to receive roughly $155,000 more. What you cannot do, and what the applicant is trying to do, is go to the state of Vermont via the Department of Economic Development and say, my project is an event space and wedding venue, and obtain $232,000 based on those representations, and then come back to the same state of Vermont via you all as the Department of Environmental Conservation and say, I would like a permit for that same project, but it's not an event space and a wedding venue. It's an inn, or it's an outdoor recreation facility. If the project was an event space and wedding venue by the applicant's own admission, when she obtained a $232,000 award from the state of Vermont, then the project is an event space and wedding venue when the applicant seeks to obtain an Act 250 land use permit from you all. Against that background, the analysis is very simple. The limited set of commercial development permitted in the RR1 district does not include event space and wedding venue. Since this is an event space and wedding venue, it does not comply with the town plan, and it fails to meet criteria 10 such that the application should be denied. Thank you.
If I may respond briefly, we use words in different places in order to show compliance with the relevant laws that are in place. We have, it should come as no surprise, Mr. Boyle, that we have been describing this project as an event space with all of these other things for, I believe it's been more than a year, it's been 15 months. I submitted a letter to you outlining why we complied with the town plan. But we've been using those terms for since I came into the case. Whether or not we're an events venue or an outdoor recreation facility, let me come at it this way. A bowling alley is a recreation facility. It can also be a venue for events. The fact that we have people coming for weddings and events where they're going to listen to music, where they're going to dance, those are all recreational events. And let me say that the town zoning ordinance, which I'm happy to submit, the relevant town ordinance lists outdoor recreational facilities as simply being a principal use of land together with any accessory buildings, which typically involves the sale of a service, including but not limited to tennis courts, golf courses, hiking trails, skating rinks, playfields, horse riding, and driving, wildlife sanctuaries, cross-country skiing, and outdoor swimming pools. Now, I admit that there is no, in that list, there's no wedding venue, and there's no listing of people listening to music. But I think that the listening to music and attending a wedding are in the same nature as all of those things that are listed as being typical recreational things. The ordinance then goes on and says the definition excludes outdoor movie theaters, firing ranges, bowling alleys, racetracks, motorbike, and ATV activity. We're none of those. So I believe that we fall within the recreational definition, and I guess I'll stop there. Well, I will say that, and I'm happy to provide the case. There is a case that is commonly quoted that says that zoning ordinances and zoning is narrowly interpreted in favor of landowners. So if we find, that means that the definition of recreation would be broadly interpreted, and we think that we fall within those definitions.
When the chips were down and they wanted $232,000, they said event space and wedding venue under paint and penalty for purchase. You are the same state of Vermont, the way that the Department of Economic Development of the state of Vermont, and you don't get to have it both ways. If it's an event space and wedding venue, then it's an event space, wedding venue now. Thank you.
Okay. So Stephen, you have party status in the criteria 10, so you have an opportunity right now to also share a comment if you would like.
I have nothing to add to what
Okay, thank you.
You know, I hear something?
Yes.
I just wanted to say that some of the recreation that, Rachel has, we have, overnight camping, I think. And for those purposes, we, that's part of the city mindset. And those who help people healthier. And something that Rachel was very good at, is people healthier. Strength here, very big. So there's that, and that is, the recreation part of the thing, not the argument, it's a retreat, which is quiet, only thoughtful, and quite often indoors. I'm really big, I don't understand why we need bullying and trying to get rid of somebody, who's trying to do something good in his town. It is really disgusting. It's disgusting.
Okay, yeah, we're gonna stop that, thank you.
I think my, man,
Yes.
so since I went back in 2002 and 3, I utilized my property for bed and breakfast and provided lodging before 2005's criteria for permit. And although Mr. Boyle may have just thrown a bunch of stuff at you, I assure you that my business was operational prior to getting the grants, because an expansion grant. And I'm not going to speak anymore on that other than I was approved for it. The CRP people are fully aware. So unfortunately, things can be portrayed many ways. My goal is to provide an awesome service, provide jobs in this town, which is in compliance with the local and regional permitting. I have the support of TORP and TME and their recommendations aligning along with Brian Johnson, who's zoning administrator. I have full permission for a bar. I asked for his permission in October 5th, 2022, to expand that to a bar studio prior to building a second bar. My neighbors have been aware of my wish to do an expansion of an event and gathering space since I moved there, and their children have come to my house every New Year's except for last year. And our children have grown up together. I want the space, to be a beautiful space that I share, and I want to get back to my community. I want other people to be able to come and have the beautiful experience that I had growing up in this time. I'm the next generation Vermonter, and I moved back here to make a difference. And that is why I'm doing what I'm doing. And although Mr. Boyle may want to sit here for a month, maybe you should take a look at what goodness I do want to be. I want to help keep people healthy in the world. I want to promote agritourism. I want to support the local farms, the local businesses. I want to keep people healthy. And I want people to be happy. and share happiness. That's what we're about. We're about the connectedness, and this community is supposed to be lifting each other, not breaking each other. I am very grateful for all of the devastators that live around me that have their properties, and I will be respectful, and I welcome that. I live here, and I need to make a living and provide a living for all of those around me. I support jobs for people that are local. They have worked with me hand in hand to make this dream come. What I'm proposing is not going to make a huge impact to this area. It is meant to supplement and care and bring people together for a happy time.
So if I could just try to succinctly respond to Mr. Boyle's argument. The argument is that we can't, the terms recreational facility and events venue are mutually exclusive, when in fact, one is the subset of the other, or can be the subset of the other. And it's a little like saying, gee, a golden retriever isn't a dog because it's a golden retriever. That's really what the argument is. And our argument is that an event space can be is a subset of recreational facilities. They can be golf courses, they can be golf, they can be all kinds of things, but among them, they can be places where people gather for yoga and weddings and musical performances. All of that's recreation.
Okay, so we're gonna move on to the reduced jurisdictional area and comments on that. Okay, you know,
Yeah.
Yeah, Mr. Andrew.
Oh,
Yeah, you want to start on the reduced jurisdictional?
yeah, I'm sorry,
That's okay,
our comments were simply that we would ask you to only take Act 250 jurisdiction over the commercial, over the potentially commercial portions of the project. We've tried to mark those off. You identified, I believe it was you who identified that we may have included some extra land, or we may have included commercial development on other land that we didn't identify. And in particular, we put lights. We proposed to install lights along what are existing walking trails. And so what we did was we removed the current lighting that we submitted, removed the lights from the areas that we want to be non-jurisdictional. And we have tried to simply anything that we're developing for commercial, we believe should be included. Anything we're not, we believe should not be included. We're not including any screening, and there is no requirement. If you require screening, then that land on which the screening would be may well be jurisdictional, but our proposal is do not require any screening, except they do not require any screening. So I don't know what more I can or should say.
Thank you.
Thanks. So we obviously start from the proposition in Rule 2C5A that the involved land is the entire tract of land. To the extent the applicant seeks to reduce the jurisdictional area to something smaller than the entire tract pursuant to 10 VSA section 6001(3)E, it is the applicant's burden to prove to you that they qualify for that exemption. To do that, they need to demonstrate that the tracts of land are, quote, devoted to farming activity, close quote. The Vermont Supreme Court has explained the farming exemption is to be read narrowly and only applied when the facts clearly support its application. Here, there's been no showing that the tracts of land are devoted to farming activity. I would point out first, the applicants haven't quite specified what the farming activity is. I've heard references to maple sugaring and I believe a hay crop. But first of all, I think it would be helpful to have clarity as to what exactly the farming activity that's taking place is. Second, even if there is, the question is not, is there something that looks like farming going on over there? The trigger is the land needs to be devoted to farming. That is its purpose, as opposed to devoted to residential living, perhaps with a garden, or devoted to residential living, perhaps with some harvesting of maple sap going on. I suspect you will hear from the applicants that they have a farm determination from the Agency of Ag, which they do. The problem with the farm determination from the Agency of Ag is that it was based on an incomplete set of information and an inaccurate set of information from the applicants. When the applicants submitted their request for a farm determination, they represented that they were engaged in the production of maple syrup to the tune of more than $2,000 a year. What the applicants did not tell the Agency of Ag was a third party, actually the applicant, Barrett Kendall's son and Rachel Kendall's brother, has an exclusive lease to the maple sap and the right to sugar the trees on the property. They went to the Agency of Ag and said, we're sugaring, and they omitted the fact that they do not have the legal right to the sap in the trees because that belongs to Jesse Kendall. That right belongs to Jesse Kendall through June 18, 2043, with an exclusive right in Jesse's favor to renew for 30 years. So Jesse Kendall will likely hold that right through June 18, 2073. Given that the request for a farm determination was based on an incomplete and misleading set of information, I would suggest you should give that farm determination no weight when you think about whether the applicants have proven to you that they qualify for the farm exemption. When Meredith Kendall's land, where the proposed parking is to be located, was most recently enrolled in the current use program, there were 0 acres of land identified as inactive agriculture. The same is true for Rachel Kendall's property. There is no land involved in active agriculture. I will reserve any further comments I have until later. At the end of the day, they have the burden of coming in and saying, this is the type of farming that we're doing. And it is the primary use of our land, not just something that happens along with the primary use of residential land. Thank you.
Believe that the fact that Rachel's brother farmed the land does not make it any less a farm. The land is primarily being used to grow trees in which maple sap is harvested, and it's primarily used to grow hay that is used to feed horses for agricultural purposes. And we believe that that qualifies the land for as an agricultural use, and we request that we be exempted from the commercial activities that will be subject to activity limited to the area of commercial. Anything else?
I'm sorry, go ahead, I apologize.
Meredith?
Meredith, yeah.
Yeah.
So I think that a lot of residents have an incorrect view of the land that we're talking about. But, my piece of 12.7 acres is completely separate from, but contiguous with all of the other acreage. And it is contiguous with Rachel's 3 to 10 acres. And, Josie does not own those trees that are on their lease, in 3 acres. And or my 12.87, which is lined with 850 trees. But that is not in the contract that I have rejected to share our contract. I also have some pictures.
But it is sugar.
Let me go. Yeah.
Those trees that you own and the regular own are sugar. In addition to what Justin sugar.
To add to this, I also have sugaring pictures that go back to, 1975, when Jesse was born. And, want to see some of those of our farm and the operation. I also, like, farms make Vermont. I really hate how the people sitting to the left of me are depicting and pulling apart a farm. We're here trying to make a community and support everybody local and keep Vermont beautiful. And the farm. And we share our property next to me. And we allow our neighbors to hike and walk our fields and come with us. And drive through them. And drive through those and take their dogs on walks through our fields.
Okay.
And I would just like to say that the farm is not just one person. Our family is a farm. My brother, my mother, and I, since the passing of my father in 2013, we farmed this together. And farms can have leases, and they're still farms.
Thank you, thank you.
The other thing I didn't mention is that I think, Meredith, at least grows a lot of vegetables. It's also meant the farmers market, commercial.
All right, thank you.
I have a question, related to current use. Because it sounds like it might be complicated, or where you have to have, so much of an income from land that's in current use. Is there paperwork that goes with that, where you have to file, and it meets all of the requirements?
Yes. We file that with our taxes as well. That criteria is
in.
correct. My mother continues to have current use. There was some. My brother pulled out some property with, his land, and I think there was an issue with Paul. Oh, he's a keep it. Well, anyway.
This project.
This project.
This component.
Yes, the land is in land use and it will continue. My land is, my 13 acres is considered a farm because 10 of the 13 acres are made sugar. My mother has 163, 168, I don't quote me on that, which is contiguous around us. Both my brother, myself, and I have 13 acres each that have farmland.
But yeah, you tax the tree.
It doesn't matter. We all share together and we're a family.
Did you have another speaker? Another comment? Did anybody have a comment? Yeah, about this specifically. Any other comment? Okay.
I do have just two other housekeeping issues before we wrap up.
Okay.
I saw in the recess order, the recess order from the prior hearing. You all referred to my client getting preliminary party status on 1, 2, 3, 7, 8, 9, and 10. We didn't ask for 9, but we did ask for 5. So I think 9 and 5 just may have been swap.
Okay.
And then I just wanted to be clear, I think everyone agrees that there are co-applicants here, Rachel Kendall and Meredith Kendall, and that both of their parcels of land are before the commission. But I just wanted to make sure we were on the same page on that.
Okay. Thank you. All right. I want to thank you all for your participation. The commission will reflect on all of the evidence and the testimony that's been presented today. Next, the commission will issue a hearing recess order, which keeps the record open for a time. Typically, a hearing recess order asks the applicant and sometimes the other parties to submit supplemental information in response to questions that were raised today, and allows parties an opportunity to respond to those supplemental filings. Once the process is complete, the commission will consider the record to be final. Once we have all the supplemental information that we need, we will deliberate and issue our decision as quickly as possible. If there are no further comments, the hearing is now in recess.
And before we end the recording, I just have a quick statement. In the beginning, we hadn't, the issue that we had was that we had not set up a Teams meeting for this prior to, we set the recess order, but we hadn't set up that Teams meeting. We were working with my admin and whose name is Gina Sansevior, and the admin for the legal division, his name is Madeline Potter, to get the meeting set up really quickly. While we were just about 10 minutes ago, we got an email. Madeline had shared that we were having this hearing today with Allison Stone, her supervisor, who's the general counsel, who took a position that we need to renotice and redo this. My hope is that when I tell her what happened, when we explain what happened, that won't be necessary. I think that it was unfortunate that the Teams meeting wasn't set up, but the hearing recess order went to all the parties. So if anyone got a question and wants to participate by remotely had an opportunity to. I believe that Gina, when she set up the Teams meeting, granted that was a little after 9 o'clock, that she sent the meeting link to everybody who was on the certificate of service, so the service list for this case. So my hope is that that was enough to provide enough notice, and that we do not have to redo this. But I just wanted to share with you before we go off the record that in the meantime, our general counsel got wind of this and was concerned and felt that we shouldn't be doing this. So
I believe that there's case law that says that anyone who gets notice and attend can't object to the fact that somebody else didn't get notice. And so if anyone comes forward and objects, then I would suggest we deal with it at that time. If no one's objecting, none of us have standing to raise that issue on behalf of other people. And there's established case law.
So and what I should also say, I apologize. I'm sorry. I hadn't picked up on that discrepancy. I'm not sure that we've had a case. The open meeting law is new. Just when I go back to the beginning of this year, I'm not sure we've had a case where we have had a hearing and then reset and restarted the hearing. And so I don't think we had.
Well, we haven't had it since January 1st.
Since January 1st, right. But it's under this new requirement that we have open meetings where we have the teams and the recording. So I just want to apologize. I mean, for some reason, the powers that be decide that we have to do this again. I sincerely apologize on behalf of all of us. But I am optimistic that we provided the notice that I think we would have provided anyway. All right, I wanted to get that on the record. So that.
I mean, for what it's worth, I agree. I think it's properly noticed as well.
With that, let's end the recording. But
Thank
before
you.
we go, I would like to just go over some hearing notice, some hearing recess items that I picked up on. I don't think we need to be on the record for this. This is something that we're gonna talk about and hopefully we can reach an agreement on. So John and Chris, some items that I think I'll be looking for in a recess memo, right? Just like the typical things that we'd be asking for that came up today that I'm not sure are in the record. Chris, I don't know if the grant application and the grant agreement that you were reading from is in the record?
They're not.
Okay, that should be part of the record. Please, you could file it along with whatever your legal arguments are gonna be, but we should get that. John, the zoning ordinance, the commission can take judicial notice of it, but it'd be helpful to have it,
Okay.
for
I
you.
can get that.
And I imagine.
And which zoning ordinance? So here's my question. I believe that the current zoning ordinance does not apply to your consideration of this project.
You can file both of them in your arguments with respect to both of them.
So
Or you can just file the one that you care about. Again, I think the commission routinely takes judicial notice of those kinds of documents. But it's nice to get them. Also, sometimes
I
they
argue
argue.
both.
And you, by the way, were citing it. The reason I took note of it, you were citing it for the definition. So the town plan refers to recreation.
Yeah.
And you were citing it to sort of provide some additional context about recreation. Okay. All right. So there was also Rachel testified about her barn studio permit. So I don't know if that's in the record, the original old permit, and that may not be. Sorry, my notes are terrible.
I'm happy to give it to you to provide to you,
Thank you.
show the clear dates.
Additionally, current use paperwork, there was reference to that. And then lastly, Chris mentioned something that I don't think is 100% clear in the application, but I want to make sure that we have this. We should have Meredith's deed reference, book and page number, the date of the deed. She may have additional parcels. I need to know all of it. I need to know everything. If you want to disagree with me, you're welcome to, but I think the tract, everything Rachel owns and everything Meredith owns. And then the issue is, what will the commission take jurisdiction over under 3001 or 6001 3E, right? Okay. And does that sound good? I feel like there was one thing from the last hearing I'm not remembering it. So that may also go into the hearing recess order. I don't want to get into timing. I think the commission can make the determination. You've heard your arguments about timing. We understand them. I'm sure the commission understands them, right? Sound good?
Sounds good.
Thank you very much.
Is it too late for me to just make a comment?
Yes, he's sorry.
Okay, all right.
Sorry.
People,